Question 1. In a situation where formal requirements conflict with employee rights, how should an employer handle the termination of an employee who is part of a unionized workforce under the National Labor Relations Act area? Assume the employee was dismissed for alleged insubordination, but the union claims it was retaliation for union activities. What legal principles must the employer consider to avoid violating labor law? A. The employer has full discretion to terminate the employee without cause, as long as the termination is documented internally. B. The employer must provide just cause for termination, comply with the collective bargaining agreement, and demonstrate that the termination was not due to union activity. C. The employer should immediately reinstate the employee to avoid legal liability, regardless of the reason for termination. D. The employer is required to notify the union of the termination but does not need to justify the dismissal under area. Answer. B. The employer must provide just cause for termination, comply with the collective bargaining agreement, and demonstrate that the termination was not due to union activity. Explanation. Under the National Labor Relations Act area, employers are prohibited from retaliating against employees for engaging in protected concerted activities, including union organizing and collective bargaining efforts. A unionized employee cannot terminate it at will if a collective bargaining agreement (CBA) is in place. That just cause a standard typically applies, requiring the employer to demonstrate valid grounds for termination. Option is incorrect because in a unionized setting, employers cannot terminate employees at will if AEA exists. Option C is incorrect because reinstating the employee without an investigation or grievance process could undermine employer rights and workplace discipline. Option D is incorrect because merely notifying the union does not satisfy the employer's obligations. They must justify the dismissal in accordance with labor laws and the CBA. Question 2. While analyzing the root causes of sequential problems in wage disputes, an employer discovers that employees in similar roles receive significantly different pay rates. Some employees allege pay discrimination under the Fair Labor Standards Act (FLSA) and the Equal Pay Act (EPA). Which of the following would be the best legal approach for the employer to address these claims? A. Maintain existing wage structures but increase transparency by publishing salary data internally. B. Conduct a pay audit to identify wage disparities, ensure compliance with equal pay laws, and adjust salaries accordingly. C. Defend the pay differences by arguing that some employees negotiated better salaries upon hiring. D. Terminate the employees who raised concerns to prevent further complaints and litigation. Answer. B. Conduct a pay audit to identify wage disparities, ensure compliance with equal pay laws, and adjust salaries accordingly. Explanation. Under the Equal Pay Act (EPA) of 1963 and the Fair Labor Standards Act (FLSA), employers must provide equal pay for equal work unless justified by bona fide factors such as seniority, merit, production levels, or a valid job-related reason. Conducting a pay audit is the best approach to proactively identify and address wage disparities while ensuring compliance with legal requirements. Option is incorrect because transparency alone does not resolve unlawful wage disparities. Option C is incorrect because salary negotiation does not justify a legal pay discrimination under the EPA if employees perform substantially equal work. Option D is incorrect because retaliation against employees who raise wage discrimination concerns is illegal under both the EPA and Title Roman of the Civil Rights Act. Question 3. During a comprehensive review of a process that needs improvement, an employer considers expanding workplace surveillance, including monitoring employee emails, keystrokes, and video recordings. What key legal concerns should the employer address under workplace privacy laws before implementing these changes? A. Employees have no expectation of privacy at work, so the employer can implement any level of surveillance without restriction. B. The employer must ensure that monitoring is conducted for legitimate business purposes and complies with federal and state privacy laws, including notifying employees where required. C. Employers should seek explicit employee consent for all forms of monitoring, including workplace security cameras and computed, to comply with the labor laws. D. Workplace privacy laws only apply to government employees, so private employers are not subject to any restrictions on workplace surveillance. Answer. B. The employer must ensure that monitoring is conducted for legitimate business purposes and complies with federal and state privacy laws, including notifying employees where required. Explanation. Under federal and state workplace privacy laws, employers may monitor employees, but must ensure the surveillance serves a legitimate business purpose and complies with legal restrictions. the Electronic Communications Privacy Act (ECPA) and various laws regulate employer surveillance of electronic communications, including emails and keystrokes. In some states, employers are required to notify employees of surveillance policies. Option is incorrect because employees do retain some reasonable expectation of privacy, particularly regarding personal communications and biometric data. Option C is incorrect because while consent is advisable, it is not always required for general workplace monitoring, especially for security and performance management. Option D is incorrect because privacy protections apply to both public and private sector employees, although the scope varies by jurisdiction. Question 4. During an emergency response where multiple areas are impacted, an employer in a large manufacturing plant suddenly lays off 50 employees without notice due to an unforeseen economic downturn. The employees argue that the employer violated federal labor laws by failing to provide advance notice of the layoffs. Under the Worker Adjustment and Retraining Notification (WARN) Act, which of the following is the most accurate legal assessment of the employer's actions? A. The employer violated the WARN Act because it is required to provide 60-day advance notice before any mass layoff, regardless of circumstances. B. The employer did not violate the WARN Act because it had fewer than 100 employees at the time of the layoffs. C. The employer may have violated the WARN Act unless it can prove that the economic downturn qualified as an unforeseeable business circumstance, which is an exception under the law. The employer did not violate the WARN Act because the layoffs were temporary and lasted less than 6 months. Answer: C. The employer may have violated the WARN Act unless it can prove that the economic downturn qualified as an unforeseeable business circumstance, which is an exception under the law. Explanation: the Worker Adjustment and Retraining Notification (WARN) Act requires employers with 100 or more full-time employees to provide at least 60 days notice before implementing mass layoff 50 or more employees at single site. However, an exception for unforeseeable business circumstances that prevents an employer from complying with this rule. The employer must still give as much notice as possible and provide clear explanation of why the notice requirement could not be met. Option is incorrect because the WARN Act does allow exceptions, including unforeseen business circumstances. Option B is incorrect because the law applies only to businesses with at least 100 full-time employees or 100 full-time equivalent employees. If the employer had fewer than 100 employees, it might be exempt, but the question states the plant is large, implying this is unlikely. Option D is incorrect because temporary layoffs of less than 6 months are generally not covered under WARN. However, the question does not specify that the layoffs were guaranteed to be temporary. This question tests an advanced understanding of mass layoffs, WARN Act exceptions, and employer obligations under labor law. Question 5. When improving a process that shows unexpected results, an employer revises its remote work policy, requiring all employees to return to the office. A group of employees with disabilities request continued remote work as a reasonable accommodation under the Americans with Disabilities Act (ADA). The employer denies all requests, arguing that remote work is not essential to their job functions. Which of the following best describes the legal obligations? A. The employer must allow remote work as an accommodation unless it can prove that physical presence is an essential job function and no other reasonable accommodation is possible. B. The employer is legally allowed to deny all remote work requests without considering individual circumstances because in-person work is company-wide requirement. C. The employer is only required to provide an alternative accommodation if the employee's disability is enough to completely prevent an office work. D. The employer can deny requests for remote work if at least one employee with the same job title is successfully working in person without accommodations. Answer A. The employer must allow remote work as an accommodation unless it can prove that physical presence is an essential job function and no other reasonable accommodation is possible. Explanation: under the Americans with Disabilities Act (ADA), employers must provide reasonable accommodations unless doing so would create an undue hardship or fundamentally alter the nature of the job. The Supreme Court has held that individualized assessments are when evaluating accommodation requests. Option is correct because an employer must engage in an interactive process to determine whether remote work is a reasonable accommodation and whether in-person presence is truly essential. The burden is on the employer to demonstrate why remote work is not feasible. Option B is incorrect because employers cannot impose blanket denials without assessing whether an employee's disability can be accommodated. Option C is incorrect because the ADA applies to a broad range of disabilities, not just those that make in-person work impossible. Option D is incorrect because reasonable accommodations are determined on an individual basis, not by comparing employees with similar job titles. This question challenges students to apply ADA principles in workplace policy changes. Question 6. In an environment where different components must interact, a new manager introduces an electronic employee surveillance system to monitor workplace productivity. Some employees argue that constant monitoring violates their privacy rights under federal and state laws. Which of the following best describes the legal framework governing workplace surveillance? A. Employers have the right to monitor all workplace activities without limitations because employees have no expectation of privacy at work. B. Employers may conduct electronic monitoring but must notify employees if required by state law, and certain types of personal communications may be protected. C. Employers are strictly prohibited from using electronic surveillance in any form unless the employee provides explicit written consent. Employers must obtain government approval before implementing electronic monitoring programs in the workplace. Answer: B. Employers may conduct electronic monitoring but must notify employees if required by state law, and certain types of personal communications may be protected. Explanation: workplace surveillance is governed by federal and state privacy laws, including the Electronic Communications Privacy Act (ECPA). While employers generally have broad authority to monitor workplace activity, some state laws require advance notice before surveillance can take place. Option is incorrect because while employers can monitor workplace communications, employees may have a limited expectation of privacy in personal emails, phone calls, or off-duty conduct. Option B is correct because the ECPA permits workplace monitoring but places restrictions on personal communications. Many states require employee consent or notification before monitoring takes place. Option C is incorrect because federal law does not require explicit written consent in all cases, though some state laws do. Option D is incorrect because government approval is not required for workplace surveillance, though regulatory agencies may investigate complaints of illegal monitoring. This question reinforces knowledge of workplace privacy laws and employee rights. Question 7. After reviewing past incidents where mistakes occurred, a hospital updates its patient confidentiality policies to comply with the Health Insurance Portability and Accountability Act (HIPAA). A nurse inadvertently sends a patient's medical record to the wrong recipient through email. The hospital immediately reports the breach and takes corrective action. Which of the following best describes the hospital's legal obligations following this breach? A. The hospital is required to notify the affected patient and, if the breach affects 500 or more individuals, report it to the U.S. Department of Health and Human Services (HS) and the media. B. The hospital is only required to report the breach internally and document it as long as it was an unintentional error. C. The hospital must immediately terminate the nurse responsible for the breach, as HIPAA violations require disciplinary action. D. The hospital is required to encrypt all patient data in the future or it will face automatic HIPAA penalties. Answer A. The hospital is required to notify the affected patient and, if the breach affects 500 or more individuals, report it to the U.S. Department of Health and Human Services (HHS) and the media. Explanation: under HIPAA's breach notification rule, covered entities, such as hospitals, must notify affected individuals without unreasonable delay and no later than 60 days after discovering the breach. If the breach affects 500 or more individuals, it must also be reported to HHS and the media. Option is correct because it accurately describes the notification requirements based on the number of individuals affected. Option B is incorrect because hospitals cannot simply internally document breaches without notifying affected individuals. Option C is incorrect because termination is not always required. Disciplinary action depends on the circumstances. Option D is incorrect because HIPAA does not mandate encryption in all cases, though encryption can help prevent breaches. This question tests knowledge of HIPAA compliance and breach response protocols. Question 8. When addressing situations where liability is unclear, a trucking company is involved in an accident where one of its drivers was using a handheld phone at the time of impact. The injured party files a lawsuit claiming the company is liable due to the driver's negligence. Under federal vicarious liability laws, which of the following is the most accurate legal interpretation of the company's responsibility? A. The trucking company is not liable because the driver was personally responsible for following company policies prohibiting handheld phone use. B. The trucking company is liable if the driver was acting within the scope of employment, even if the company did not explicitly approve the phone use. C. The trucking company is only liable if it can be proven that the driver was using the phone for company business at the time of the accident. D. The company is not liable unless the driver has documented history of unsafe behavior and the company failed to take corrective action. Answer: B. The trucking company is liable if the driver was acting within the scope of employment, even if the company did not explicitly approve the phone use. Explanation: under vicarious liability, respondent, superior, and employer can be held legally responsible for an employee's actions if the employee was acting within the scope of employment at the time of the incident. Option is incorrect because employers can still be liable even if policy was in place. Option B is correct because the company may be liable even if the driver's actions were against company policy, as long as the driver was performing job duties. Option C is incorrect because personal versus business use of the phone does not solely determine liability. Option D is incorrect because history of unsafe behavior is not required to establish vicarious liability. This question examines employer liability in negligence cases. Question 9. As part of a broader strategy to mitigate risk, a construction company requires all subcontractors to carry general liability insurance. If subcontractors' work leads to property damage and the client demands compensation, the subcontractor's insurance denies the claim, arguing that the company's policy excludes damages from faulty workmanship. Under standard contract law, which of the following best describes the construction company's potential liability? A. The construction company is automatically liable for all damages caused by subcontractors under general liability principles. B. The construction company is not liable because it required the subcontractor to have insurance, shifting responsibility. C. The construction company may be liable if it exercised control over the subcontractor's work or failed to ensure proper coverage. D. The construction company is only liable if court finds the subcontractor was improperly licensed at the time of the work. Answer: C. The construction company may be liable if it exercised control over the subcontractor's work or failed to ensure proper coverage. Explanation: construction companies can be held liable for subcontractors' work under certain circumstances, especially if they exercise control over operations. Option is incorrect because liability depends on contract terms and the level of control the company had over the subcontractor's work. Option B is incorrect because requiring insurance does not automatically shield company from liability. Option C is correct because if the company exercised control or failed to verify proper coverage, it may share liability. Option D is incorrect because licensing status alone does not determine liability. This question evaluates contract law and risk management in construction. Question 10. When analyzing factors that influence decision-making, an employer implements a diversity hiring policy that prioritizes candidates from underrepresented backgrounds. A rejected applicant files a lawsuit claiming reverse discrimination under Title Roman of the Civil Rights Act. Which of the following is the best legal argument in defense of the employer's policy? A. The employer's policy is illegal because all hiring decisions must be made solely on merit, regardless of diversity goals. B. The employer's policy is legal if it is narrowly tailored and does not impose rigid quotas, ensuring all candidates are given fair consideration. C. The employer is required to hire candidates based on racial diversity percentages that match the surrounding community. D. The employer must prove that no better qualified candidates were rejected solely based on diversity considerations. Answer: B. The employer's policy is legal if it is narrowly tailored and does not impose rigid quotas, ensuring all candidates are given fair consideration. Explanation: under Title Roman of the Civil Rights Act, diversity-based hiring policies are permissible if they are narrowly tailored and do not involve quotas. Courts have ruled that affirmative action programs can be valid if they serve legitimate business interest and do not unfairly disadvantage applicants. Option is incorrect because diversity policies can be legal under certain conditions. Option B is correct because policies that encourage diversity without strict quotas are legally supported. Option C is incorrect because no law mandates that hiring match community demographics exactly. Option D is incorrect because the law does not require proving that no better qualified candidates were passed over. This question examines employment law and diversity hiring policies. Question 11. When evaluating the potential risks associated with new business ventures, a retail company considers expanding its operations internationally. The company must assess potential currency exchange risks, political stability, and foreign labor laws before proceeding. Which of the following is the most effective strategy to mitigate these risks? A. Rely on local suppliers to handle all financial transactions, thereby eliminating the company's exposure to currency fluctuations. B. Conduct thorough political risk analysis, implement currency hedging strategies, and ensure compliance with local labor regulations before expansion. C. Expand operations without adjusting pricing to ensure consistency across all markets, regardless of local economic conditions. D. Hire for workforce without consulting legal experts, assuming that labor laws are similar to those in the company's home country. Answer: B. Conduct a thorough political risk analysis, implement currency hedging strategies, and ensure compliance with local labor regulations before expansion. Explanation: expanding internationally introduces multiple risks, including currency exchange fluctuations, legal compliance issues, and political instability. Option is incorrect because relying solely on local suppliers does not eliminate exposure to currency risks. If the company is still affected by fluctuations in exchange rates when converting profits. Option B is correct because a comprehensive approach, including political risk analysis, currency hedging such as forward contracts, and labor law compliance, effectively mitigates major risks associated with global expansion. Option C is incorrect because ignoring local economic conditions can lead to pricing that is uncompetitive or unsustainable. Option D is incorrect because assuming labor laws are the same as in the company's home country can lead to legal violations and compliance issues. This question assesses international business strategy and risk management. Question 12. After reviewing customer feedback on product reliability, a technology company discovers that one of its best-selling products has higher than expected failure rates within the first year of use. To maintain customer trust and comply with consumer protection laws, which of the following would be the most legally and ethically responsible course of action? A. Quietly replace defective products for customers who complain, but avoid issuing a public recall to minimize reputational damage. B. Issue a voluntary recall, offer free repairs or replacements, and communicate openly about the defect with consumers and regulatory agencies. C. Continue selling the product as is and include a disclaimer in the warranty policy stating that early failures are possible. D. Shift blame to third suppliers and deny liability, as the company did not manufacture all components internally. Answer: B. Issue a voluntary recall, offer free repairs or replacements, and communicate openly about the defect with consumers and regulatory agencies. Explanation: consumer protection laws require companies to address known defects in products that could pose risks to customers. Transparency and proactive action are key to maintaining brand reputation and avoiding legal repercussions. Option is incorrect because hiding a defect while replacing products only for those who complain is unethical and could lead to lawsuits. Option B is correct because a voluntary recall with free repairs or replacements ensures legal compliance and builds consumer trust. Regulatory agencies such as the Consumer Product Safety Commission (CSC) require companies to report and address defects in a timely manner. Option C is incorrect because merely including a disclaimer does not absolve a company of liability under consumer protection laws. Option D is incorrect because shifting blame to third parties does not eliminate legal liability. The company is still responsible for the final product. This question tests knowledge of consumer protection laws, corporate ethics, and risk management. Question 13. In a high-stakes environment where multiple challenges require careful prioritization, a hospital is implementing a new electronic health records system. However, doctors and nurses report workflow disruptions, increased documentation time, and technical issues that affect patient care. What is the best approach to mitigate these issues while ensuring a smooth transition? A. Delay the full implementation until technical issues are resolved, even if it means postponing compliance deadlines. B. Provide extensive real-time training, assign its support teams on site, and implement gradual system rollouts to minimize disruptions. C. Require all staff to immediately use the new system without adjustments, ensuring complete adoption without delays. D. Allow doctors to continue using paper records temporarily, while gradually phasing in the new system. Answer: B. Provide extensive real-time training, assign its support teams on site, and implement gradual system rollouts to minimize disruptions. Explanation: Transitioning to an AS system is a complex process that requires proper training, technical support, and phased implementation to minimize disruptions. Option is incorrect because delaying indefinitely can cause compliance risks. Option B is correct because combining training, on-site support, and phased rollout ensures a smooth transition while maintaining patient care. Option C is incorrect because a rigid approach leads to frustration and errors. Option D is incorrect because hybrid use of paper and digital records increases errors and inefficiencies. Question 14. During an emergency response where multiple areas are impacted, a city faces widespread power outages, disrupted communication networks, and transportation failures due to a hurricane. As an emergency response coordinator, what is the most effective strategy to restore stability and minimize further risk? A. Focus exclusively on restoring power to government buildings and hospitals, delaying other services until full assessment is complete. B. Establish communication command centers, deploy emergency resources based on priority needs, and coordinate with federal agencies for additional support. C. Wait for damage reports from all affected districts before initiating any recovery efforts to ensure a fully informed response. D. Encourage citizens to remain self-sufficient for as long as possible and avoid mobilizing emergency responders prematurely. Answer. B. Establish communication command centers, deploy emergency resources based on priority needs, and coordinate with federal agencies for additional support. Explanation. In emergency response, rapid coordination of communication, resource allocation, and federal assistance is key. Option is incorrect because focusing only on select locations ignores widespread needs. Option B is correct because a structured response with clear priorities ensures efficiency in restoring essential services. Option C is incorrect because waiting for complete data before acting delays critical relief efforts. Option D is incorrect because relying solely on self-sufficiency risks worsening the crisis. Question 15. When implementing backup procedures across various departments, a global financial institution needs to ensure continuity of operations in the event of a cyber attack. What is the most effective strategy to strengthen cyber resilience while maintaining customer trust? A. Invest in redundant cloud-based systems, real-time cybersecurity monitoring, and rapid incident response plans to minimize downtime. B. Store all backups on physical drives disconnected from the network to prevent cyber threats from spreading. C. Rely on employees to detect and report cyber threats manually rather than implementing automated monitoring systems. D. Assume that existing firewall protections are sufficient and continue operations without additional cybersecurity investments. Answer A. Invest in redundant cloud-based systems, real-time cybersecurity monitoring, and rapid incident response plans to minimize downtime. Explanation. Financial institutions must have robust cyber resilience strategies that include real-time monitoring, cloud-based redundancies, and rapid incident response. Option is correct because a multi-layered security strategy ensures operational continuity. Option B is incorrect because offline backups alone do not address real-time threats. Option C is incorrect because relying solely on manual detection increases the risk of undetected breaches. Option D is incorrect because assuming existing firewalls are sufficient ignores evolving cyber threats. Question 16. During a major transformation where existing methods of employee classification are being reevaluated, a nationwide logistics company finds that many of its delivery drivers have been misclassified as independent contractors rather than employees. As a result, the company has avoided paying overtime wages, benefits, and payroll taxes. A group of drivers files a lawsuit claiming they should be classified as employees under the Fair Standards Act FLSA. Which of the following factors would most likely determine whether the drivers should be classified as employees or independent contractors? A. The number of hours the drivers work per week. B. Whether the company provides the drivers with tools, uniforms, and vehicles. C. Whether the drivers prefer to be classified as independent contractors. D. The company's business model and financial structure. Answer. B. Whether the company provides the drivers with tools, uniforms, and vehicles. Explanation. Under the economic realities test used by courts and the Department of Labor, DOL, determining whether a worker is an employee or an independent contractor depends on several factors, including degree of control the company has over the worker, provision of tools, uniforms, and equipment, workers' opportunity for profit or loss, permanency. Relationship. If the company provides delivery drivers with vehicles, uniforms, and sets their schedules, they are likely to be considered employees rather than independent contractors. A. Incorrect. The number of hours worked does not solely determine classification. Independent contractors may work full-time but still be considered non-employees. C. Incorrect. Workers' preference does not override legal definitions of employment. D. Incorrect. The company's business model does not dictate whether the worker is an employee. Employment status depends on the level of control and economic dependence. Question 17. While investigating the complicated issue between different divisions of a corporation, HR managers find that employees in one department are consistently paid less than those in another department for performing substantially similar work. The affected employees file a claim under the Equal Pay Act (EPA). What must the employees prove to establish a violation of the Equal Pay Act? A. The pay disparity exists due to market conditions. B. The jobs require equal skill, effort, and responsibility under similar working conditions. C. The employees have worked at the company for the same amount of time. D. The pay gap is due to differences in educational background. Answer. B. The jobs require equal skill, effort, and responsibility under similar working conditions. Explanation. Under the Equal Pay Act of 1963, employers cannot pay different wages to employees of different genders who perform substantially equal work unless the difference is based on a seniority system, a merit system, a system measuring earnings by quantity or quality of production, a factor other than sex. To prove a violation, employees must show that their jobs require equal skill, effort, and responsibility, and they work under similar conditions. A. Incorrect. Market conditions do not justify unlawful pay discrimination. C. Incorrect. The length of employment is irrelevant to an EPA claim. D. Incorrect. Educational background is only relevant if it directly affects job responsibilities. Question 18. In a high-stakes environment where multiple challenges must be addressed simultaneously, a hospital system is facing a shortage of nurses and considers offering financial incentives. However, some nurses allege that male nurses are being offered higher signing bonuses than female nurses. Under which law would this scenario most likely be a violation? A. Titlement of the Civil Rights Act. B. Family and Medical Leave Act (FLA). C. National Labor Relations Act (ELRA). D. Occupational Safety and Health Act (OSHA). Answer. A. Titlement of the Civil Rights Act. Explanation. Title Roman of the Civil Rights Act of 1964 prohibits discrimination based on sex, race, color, national origin, and religion in employment practices, including hiring, pay, and promotions. Offering higher bonuses to male nurses solely based on gender would be unlawful gender discrimination. B. Incorrect. The FLA governs leave policies but does not regulate hiring incentives. C. Incorrect. The ERA relates to union activities, not gender-based pay disparities. D. Incorrect. OSHA deals with workplace safety, not wage discrimination. Question 19. While managing a hybrid approach where timing issues affect employee availability, a software company limits remote work options for certain employees based on their age, citing productivity concerns. A 58-year-old employee files a claim under the Age Discrimination in Employment Act (ADEA). Which of the following must the employee prove to establish a claim under the ADEA? A. The company has a written policy that prohibits hiring older employees. B. The company discriminated against them based on their age, 40 or older. C. They received lower wages than younger employees. D. Their performance evaluations were lower than younger employees. Answer. B. The company discriminated against them based on their age, 40 or older. Explanation. Under the ADEA 1967, it is illegal for employers to discriminate against employees aged 40 or older in hiring, promotions, or work conditions. The employee must show that age was a determining factor in the employer's decision. A. Incorrect. ADEA claims do not require written policies. C. Incorrect. Wage disparity alone does not prove age discrimination. D. Incorrect. Poor performance evaluations must be shown to be pretextual. Question 20. During a seamless transition where continuity must be maintained, a financial firm implements AI-driven employee monitoring tools that track productivity. Some employees claim these tools violate their privacy rights. Which law primarily regulates employee privacy in the workplace? A. The Stored Communications Act. B. The Employee Polygraph Protection Act. C. The Electronic Communications Privacy Act (ECPA). D. The Fair Labor Standards Act (FLSA). Answer. C. The Electronic Communications Privacy Act (ECPA). Explanation: the ECPA 1986 regulates electronic surveillance and monitoring of employees' communications. Employers can monitor workplace devices but must inform employees and comply with privacy laws. A. Incorrect. The Stored Communications Act protects electronic records but does not cover workplace monitoring. B. Incorrect. The Employee Polygraph Protection Act bans most employee lie detector tests. D. Incorrect. The FSA covers wage and hour laws, not privacy. Question 21. In a situation where resource allocation becomes increasingly difficult, a company undergoing financial struggle decides to lay off older employees first to cut costs. A 62-year-old employee claims this is a violation of the Age Discrimination in Employment Act (ADIA). Which of the following defenses could the company use to justify its decision? A. The employee was less productive than younger employees. B. The layoffs were based on a legitimate business necessity and not age. C. The employee's retirement was coming up soon. D. The company has history of hiring older employees. Answer: B. The layoffs were based on a legitimate business necessity and not age. Explanation: under the ADIA 1967, it is illegal for employers to make employment decisions based on age alone for employees 40 and older. However, if the employer can show the layoff was due to business necessity, g. financial instability, and not directly age-related, the decision may be lawful. A. Incorrect. Productivity issues must be documented and not used as pretext for age discrimination. C. Incorrect. Imminent retirement does not justify forced termination. D. Incorrect. Past hiring practices do not excuse present discrimination. Question 22. While updating traditional approaches where interconnections between teams must be restructured, an HR director prohibits employees from discussing wages with one another. Employees challenge this under the National Labor Relations Act (ELRA). Which of the following is the most accurate legal assessment? A. The company is within its rights to ban wage discussions. B. The ban violates the ELRA because employees have the right to discuss working conditions. C. The policy is legal if employees sign a confidentiality agreement. D. The rule only applies to non-unionized employees. Answer: B. The ban violates the ARA because employees have the right to discuss working conditions. Explanation: ARA 1935 protects employees' rights to engage in concerted activity, including discussing wages, hours, and working conditions. Employers cannot prohibit these discussions. A. Incorrect. Wage discussions are legally protected. C. Incorrect. Confidentiality agreement cannot override area rights. D. Incorrect. The LRA applies to both unionized and non-unionized employees. Question 23. During an emergency response where multiple areas are impacted, a city implements mandatory overtime for emergency responders due to a natural disaster. A group of firefighters claims this violates the Fair Labor Standards Act (FLSA). Which of the following statements is most accurate? A. The FLSA prohibits mandatory overtime in emergency situations. B. The FLSA allows mandatory overtime but requires overtime pay. C. The FSA does not apply to emergency responders. D. The firefighters can refuse overtime if they have worked 40 hours. Answer: B. The FLSA allows mandatory overtime but requires overtime pay. Explanation: the FLSA 1938 does not limit the number of hours an employee can work but requires employers to pay overtime 1.5x the regular rate for hours exceeding 40 per week. A. Incorrect. The FLSA does not prohibit overtime. C. Incorrect. The FLSA applies to emergency responders. D. Incorrect. Employees cannot refuse overtime unless protected by union contract or local law. Question 24. In a multi-location scenario where consistency requirements must be maintained, a national retail chain uses background checks in hiring. However, a disproportionate number of applicants from a protected racial group are rejected. Under which law could these hiring practices be challenged? A. The Americans with Disabilities Act (ADA). B. The Occupational Safety and Health Act (OSHA). C. Title Roman of the Civil Rights Act. D. The Fair Credit Reporting Act of CRA. Answer: C. Title Owner of the Civil Rights Act. Explanation: Title Owner of the Civil Rights Act of 1964 prohibits employment discrimination based on race, color, national origin, sex, or religion. Even if a background check policy is neutral on its face, it may be unlawful if it disproportionately affects a protected group. Disparate impact. A. Incorrect. The ADA relates to disability discrimination, not race. B, incorrect. OSHA focuses on workplace safety. D, incorrect. The IFCRA regulates credit reports, not discrimination. Question 25. While examining inconsistencies across various units, an airline notices that pregnant employees are being denied light-duty work assignments that are given to other employees with medical restrictions. Under which law could this practice be challenged? A. The Pregnancy Discrimination Act, PDA. B. The Worker Adjustment and Retraining Notification 1 Act. C. The Genetic Information Non-Discrimination Act, GINA. D. The Fair Credit Reporting Act of CROE. Answer A. The Pregnancy Discrimination Act, PDA. Explanation. The PDA 1978 prohibits discrimination based on pregnancy, childbirth, or related medical conditions. If an employer provides light-duty work for other temporarily disabled employees, they must offer the same accommodations to pregnant employees. B, incorrect. The WARN Act deals with mass layoffs, not pregnancy. C, incorrect. GINA protection. Information, not pregnancy status. D, incorrect. The IFCRA regulates credit reporting. Question 26. When implementing new protocols in a shared environment, a company mandates that all employees receive a flu vaccination to reduce sick leave. An employee refuses due to religious beliefs and is terminated. The employee files a lawsuit under Title IX of the Civil Rights Act of 1964. Which of the following is the most legally sound employer? Response. A. The employer can enforce the policy since it applies to all employees equally. B. The employer must provide a reasonable accommodation unless it causes undue hardship. C. The employer can refuse accommodations for religious beliefs in health-related policies. D. The employer is not required to justify the termination if the policy is company-wide. Answer B. The employer must provide a reasonable accommodation unless it causes undue hardship. Explanation. Under Title IX, employers must reasonably accommodate employees' religious beliefs unless doing so poses an undue hardship, significant difficulty, or cost. This may include allowing employees to wear masks or work remotely instead of requiring vaccination. A. Incorrect. Neutral policy can still be discriminatory if it disproportionately affects religious employees. C. Incorrect. Employers cannot deny religious accommodations without proving undue hardship. D. Incorrect. Employers must justify the termination under anti-discrimination laws. Question 27. During a major transformation where existing methods must be adjusted, a company introduces a new employee monitoring system that tracks keystrokes and screen activity. An employee claims this violates their privacy rights. Under which law could the employee challenge the monitoring? A. The Electronic Communications Privacy Act, ECPA. B. The Fair Labor Standards Act, FLSA. C. The Americans with Disabilities Act, ADA. D. The Occupational Safety and Health Act, OSHA. Answer A. The Electronic Communications Privacy Act, ECPA. Explanation. The ECPA 1986 regulates electronic surveillance and workplace monitoring. While employers can monitor employee activity on company devices, they must notify employees and avoid unauthorized interception of private communications. B. Incorrect. The FLSA governs wages and overtime, not privacy. C. Incorrect. The ADA relates to disability rights, not electronic monitoring. D. Incorrect. OSHA focuses on workplace safety, not privacy. Question 28. In a high-stakes environment where multiple challenges impact decision-making, a company outsources a portion of its workforce to an overseas vendor, some U.S. employees claim this violates the Worker Adjustment and Retraining Notification (WARN) Act. Which of the following is the most accurate legal assessment? A. The WARN Act applies only if 50 employees are laid off in a single site. B. The WARN Act does not apply if jobs are outsourced rather than eliminated. C. Employers must always provide 90 days notice before outsourcing jobs. D. The WARN Act only applies to public sector employers. Answer A. The WARN Act applies only if 50 employees are laid off in a single site. Explanation. The WARN Act 1988 requires employers with 100 employees to provide 60 days notice before mass layoffs or plant closures. However, it only applies if 50 or more employees at a single site lose their jobs. B. Incorrect. Jobs being outsourced rather than terminated may not trigger WARN Act protections. C. Incorrect. The law requires 60 days notice, not 90. D. Incorrect. The WARN Act applies to private sector employers, not just public entities. Question 29. While managing a hybrid approach where timing issues arise, an employer offers some employees remote work but denies others in similar roles, One employee files a complaint under the Americans with Disabilities Act (ADA) stating they need remote work due to a disability. Which of the following is the best legal response for the employer? A. The employer must provide remote workers a reasonable accommodation unless it causes undue hardship. B. The employer can deny remote work if it is not part of the standard job description. C. The ADA does not require employers to offer remote work as an accommodation. D. Employers can make remote work decisions based on business preference alone. Answer A. The employer must provide remote work as a reasonable accommodation unless it causes undue hardship. Explanation. Under the ADA 1990, employers must offer reasonable accommodations to employees with disabilities unless it creates an undue hardship. If other employees in similar roles are allowed to work remotely, the employer must justify why. A disabled employee cannot. B. Incorrect. Job descriptions do not override it. Obligations. C. Incorrect. The ADA allows remote work accommodations if feasible. D. Incorrect. Employers must consider disability accommodations before denying requests. Question 30. In a scenario where efficiency decreases across multiple departments, a company decides to classify certain workers as independent contractors instead of employees to cut costs. Some workers challenge this under the Fair Labor Standards Act (FLSA). Which of the following is the most accurate legal consideration? A. Employers can classify workers however they choose if contracts are signed. B. Independent contractors must meet certain legal criteria under the FLSA. C. The FLSA only applies to full-time employees, not contractors. D. Employers can avoid FLSA compliance by calling workers freelancers. Answer B. Independent contractors must meet certain legal criteria under the FLSA. Explanation. The FLSA 1938 protects employee rights but does not cover independent contractors. However, the government applies an economic reality test to determine if a worker is truly an independent contractor. The key factors include control over work schedule and tasks, who provides work equipment, opportunity for profit loss, permanent relationship. A. Incorrect. Contracts do not determine classification alone. C. Incorrect. The FLSA covers misclassified workers if they should legally be employees. D. Incorrect. Renaming employees as freelancers does not bypass the law.